I found out about this document because someone on Twitter posted that the ex-judge at the end where she signed it used the address of her crematorium. And because of that, I have high hopes that this is going to be entertaining. This is defendant's motion for new trial and for leave to interview jurors. So they want to interview some jurors. Let's dig into it. One, a jury convicted Mrs. Adelson as charged in the indictment on September 4th, 2025. Two, this motion is timely, filed within 10 days of the rendition of the verdict pursuant to the rules. Three, Mrs. Adelson requests leave to interview juror number 5 and juror number 7. 4. Mrs. Adelson files this motion for new trial on the following grounds. 1. Juror misconduct. 2. Verdict is contrary to the law or weight of the evidence. 3. Court erred in a decision of any matter of law which arose during the trial. 4. For other cause not due to Mrs. Adelson's fault, she did not receive a fair and impartial trial. Really now? So, here we have the motion for leave to interview the jurors. And here we have the information. It says, in the court's preliminary instruction to the jury, the standard instruction was read. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication, such as emailing, text messaging, posting information on social media, or a website or any other form of communication. Okay. Subsequent to the trial, juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. I saw some of this myself. In reviewing juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26, 2025. A flash drive with this video will be provided to the court, as the underside has been informed that the particular TikTok was deleted by the juror from her account. Now, they didn't post information other than that they were a juror, which I've seen enough cases that generally saying you're a juror is allowed. You might not be able to say which case I've seen that mentioned, but saying you are a juror is something I've never seen not allowed to be mentioned. And I have went through these TikToks a while back, and I didn't see anything inappropriate during the trial. So this seems like nonsense to me. The undersigned seeks to interview juror number 7 concerning her social media activity during the trial. Additionally, juror number 5 appeared on the podcast Surviving the Survivor. During his appearance, he revealed he considered how Mrs. Adelson reacted to the evidence and testimony admitted during the trial. Although he subsequently stated he, in quotes here, obviously did not consider that during deliberations, that he considered Mrs. Adelson's reactions whatsoever as concerning, as her reactions are not evidence or extrinsic or external, rather than which adheres in the verdict. Listen, right? Like, what are the is the jury not supposed to notice her making faces, right? Like, they say, obviously, it's going to be something you notice, right? You're going to see her reactions. They didn't put a shawl over her head, right? So they're saying that it's unfair that a juror saw her reactions, because she made a lot of reactions, a lot of faces during this trial. He saw the reactions, and because she's so reactive, he definitely saw it, but he didn't consider it. And even then, they want to interview juror number 7 concerning his consideration of Mrs. Adelson's reactions to the evidence. So, this is something also I want to mention. It's not in this, but I have seen some other people mention that at least one juror, I don't know what one, that has been doing interviews has requested, at least of some people, money to do an interview. That has upset a lot of people. They don't think that's okay. At the end of the day, if you speak about your experience at all, they are putting on the risk of filings like this. They might have to sit there and deal with Donna's attorneys. Doesn't seem to have anything that they did wrong listed here, but they might have to deal with Donna's attorneys nonetheless. And here is just going to be some matter of law when it comes to the juror misconduct. So let's go to the verdict is contrary to the law or weight of the evidence. The only avenue for judicial review of the weight of the evidence by motion for new trial. Okay. I'm trying to see them give anything specific about this case. Um, Count 1, first-degree murder. At this stage, the court must make a finding that Patricia Byrd was credible before considering Mrs. Adelson's alleged confession to Byrd. Under no set of circumstances can Byrd be considered credible. She testified the defense interrogator with whom she spoke was a white woman. Miss Kahn was obviously not white. She further testified that she told Mr. Barnes and Mrs. Kahn that Mrs. Adelson confessed and that Mrs. Adelson offered her financial incentives in exchange for perjured testimony. Both Mr. Barnes and Mrs. Kahn disputed those claims. Additionally, Ms. Kahn testified that she never met with Mrs. Adelson. Thus, unless the court were to believe defense counsel conveyed to Ms. Kahn that Ms. Byrd was to be offered money for false testimony, Ms. Byrd's testimony should be disregarded completely. The same is true of Drina Bernhardt. Ms. Bernhardt's motivation to lie was and is significant. With 27 felony convictions and facing a mandatory 15-year prison sentence as a prison releasee reoffender, Bernhardt's credibility was substantially impeached. The only one who testified this was Miss Adelson's word rather than Ms. Bernhardt was Ms. Bernhardt. However, the surveillance video admitted into evidence establishes that she and Miss Adelson worked together to write the script. The theory of the state's case was the defendant is guilty as principal to the charge of murder because she agreed to the plan that was carried out by her son, Catherine Magbagua, Sigfredo Garcia, and Luis Riviera, and that she paid for the crime to be carried out. There is no evidence that Mrs. Adelson committed any act or uttered any words in furtherance to the offense prior to it being completed, and for that reason the evidence is not sufficient to support a conviction as a principal to first-degree murder. Additionally, there is no evidence other than adoptive admission from Charlie Adelson's trial testimony that Mrs. Adelson was aware of her son's plans until September 17, 2014. Okay. So, because Byrd and Bernhardt were allowed to testify, and the jury was able to take that into account, they won a new trial. But also, they're saying here that there's no evidence she was aware prior to September 17th. Although a person can be convicted as a principal to a criminal offense based on words alone, there must be competent substantial evidence where words were spoken in advance of the crime. A person can be convicted as principal to a crime under that section only if there is evidence that she committed some act or uttered some words. As acknowledged previously, intent is an operation of mind and may be established by circumstantial evidence. There certainly is no direct evidence Mrs. Adelson intended for Mr. Markel to be killed. However, there also is no circumstantial evidence that Mrs. Markel wanted Mr. Markel to be killed. Okay. Even if there was, there is no evidence to establish a second element that she did some act to assist the other person actually committing the crime. The money? The crime was committed because of money, and she was involved with the money. That's the act. That's one of the acts. Magbagua testified that per Charlie Adelson, his parents had stopped by his residence July 18, 2014, after Mr. Markel was murdered. However, Magbagua did not testify that Mrs. Adelson or her husband dropped off any money that night. The state's expert agreed the state could not place Mrs. Adelson or Dr. Harvey Adelson's handsets at Charlie Adelson's residence July 18th. This is the same argument they failed in front of the jury. Donna said she was outside of his house in a text message. And the defense was focused on the idea that you shouldn't believe the words that Donna says back then because Donna didn't say them now. Which Donna isn't saying anything now. But back then, she said she was outside of his home. And they're like, well, why would she wait outside for him? Which, again, no one made that argument. The defense even made the argument she had a way to get in. She knew a way to get into his home. She could have waited inside for him. It doesn't preclude her from being out there. Even if Mrs. Adelson and Dr. Harvey Adelson did stop at his residence, so they're admitting, it would have been approximately 9 hours after Mr. Markel was shot. Again, the argument is she paid for it. you're going to pay for it. Like, are they arguing? Are they really trying to argue that if you plan a shooting and you pay for it after the fact, you don't get a first-degree murder charge? That you can downgrade the charge you can get by paying after the fact? Is that what they're actually going to go for here? What? In fact, at the state's request, the court found that Mrs. Adelson had adopted Charlie Adelson's prior testimony. This included Charlie's testimony that he paid Mambagwa from his own money, which he kept stapled as confirmed by Mambagwa, Ryan Fitzpatrick, and Jude Mchiha. Charlie's testimony also included the fact that he did not tell Mrs. Adelson he paid Mambagwa for the shooting until September 17, 2014. No evidence was presented that Mrs. Adelson was aware of anything other than Mr. Markel had been killed prior to September 17, 2014. The defendant in Staten drove the perpetrators to the scene of the crime, waited across the street while they were committing the crime, and then drove away in the car. In these circumstances, a jury could legitimately infer the petitioner was a participant in the crime, and thus the Supreme Court concluded that the evidence supported the defendant's conviction as a principle. Affirmative acts such as these are common, so that's just some case law they're citing. In this case, such as in Ammons, there is no evidence the defendant did some act. And they're quoting it up here. To state his conviction as principle, the state was required to establish that the appellant intended the crime be committed and do some act to assist the other person in actually committing the crime. I mean, you could argue that if they're saying that she paid for it, and then, or even if she just washed the money to help cover it up, that's still assisting in the murder, right? I mean, they're obviously going to try anything. It's just the other cases listed there. The state may argue that Mrs. Adelson act of delivering money to her son's house sufficiently establishes that what she did the day of the murder. However, nothing about delivering money after the murder could support her conviction as a principle to the murder itself. Come on. Come on. Additionally, there is no evidence of what Mrs. Adelson agreed to pay the killers prior to the murder. In fact, Mambagwa testified during the trial that the amount of payment was never addressed prior to the murder. So if they're arguing here, they're arguing, from the way I'm taking it, is that if you told someone, I'll pay you to commit crime, right? They commit the crime, and then you pay them, but you never said how much, it's not premeditated. I mean, we know it wasn't a predetermined amount. They were paying her monthly until they had the bump, right? Like, she was probably going to get taken care of forever. The state may also argue that Mrs. Adelson necessarily provided Mr. Adelson's tag number to her son, who gave it to Mambagwa. So they're going to argue now. So now they're going to argue against the fact that she had his, information saved. Who then gave it to Garcia Riviera? However, there is no evidence a tag number was ever given to Charlie, let alone Mambagwa, Garcia, or Riviera. Except they had it. It was said at the trial, right, that they had it. So how'd they get it? Even if such evidence existed, there is no evidence it was done on or even before July 18, 2014. No evidence was admitted during trial to establish the purpose for which Miss Adelson had the tag number on her 2014 planner. Because she's crazy? Because she was stalking him, basically, keeping track of his every move? So she could use it against him in the future? Like we saw from the divorce? Finally, with respect to the second principle instruction, there is no evidence Mrs. Adelson made any payment prior to the murder, or that she, again, prior to the murder, or trying to excuse if it's after, or that she, rather than Charlie, promised any payment prior to the murder. So now they're saying that part. Okay. At worst, even if Mrs. Adelson dropped cash off at Charlie's house after the murder and signed the payroll checks after the murder, would establish her culpability as an accessory after the fact, but are not competent evidence of principle to first-degree murder. So I don't think that really did much. And then we have count 2, conspiracy to commit first-degree murder. was that Mrs. Adelson agreed with Charlie Adelson and others to kill Mr. Markel. As was clear throughout the trial, there was no direct evidence of Mrs. Adelson's involvement in the conspiracy. The state provided as Charlie Adelson, Meng Bagwell, Riviera, Garcia. The primary evidence against Mrs. Adelson, the motive, Mrs. Adelson desired to have her daughter and grandsons moved to South Florida. Although there was certainly evidence Mrs. Adelson was not happy with the way Mr. Markel treated her daughter in the litigation process, there was no evidence Mrs. Markel said or did anything to suggest Mr. Markel be killed a year after relocation was denied and the dissolution of marriage had been settled. There was also no evidence Mrs. Adelson was even aware, according to Jeff Lacasse, that Charlie Adelson looked into hiring a hitman in the summer of 2013. I mean, the thing is, right? She doesn't need to know if he looked into a hitman in 2013. It matters if he looked into it at any point before Dan was murdered. The undersigned asked the court to consider the evidence without the state's spin placed on it. Certainly, Mrs. Adelson suggested crazy and offensive methods to her daughter to convince Mr. Markel to change his mind about relocation. Once the dissolution was final on July 31st, 2013, what evidence exists that Ms. Markel continued to have a motive for Mr. Markel to be out of the picture? And they have to put, I noticed they already have something here. If we ignore the emails where she suggested her daughter ensure Mr. Markel be obliged to share expenses with her for her son's college education, etc., all events which would necessarily take place after he was killed, there is none. What? What would be the motive? Here is a long list of things that could be the motive because they only stop because he's dead. Excuse me? Where is the evidence Mrs. Adelson agreed, conspired, combined, or confederated with anyone else that Mr. Markel be killed? There is none. The state's entire case is premised on speculation, impermissible stacking of inferences, and theory. Without the speculation, theory, and impermissible stacking of inferences, there was no evidence Mrs. Adelson ever agreed for Mr. Markel to be killed. The evidence of flight was not that she was fleeing to avoid prosecution. Oh my, listen. We've already been through the trial, right? She was fleeing. The evidence of flight was not that she was fleeing to avoid prosecution, but that at the time in November 2023, she believed that her son's innocence and that if he were convicted, the state would next turn their attention to her. Rather than conscious of guilt, that is evidence of her fear that the witch hunt would continue. Hold up. Rewind. So, she fled because she was afraid the state's attention would turn to her, which is for prosecution, but she wasn't fleeing to avoid prosecution. She was fleeing a witch hunt, but that witch hunt in reality was a prosecution where she was found guilty. That's just admitting she fled for prosecution. The trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. Although the fancy presentations, there was nothing fancy in this trial, by the way, in my opinion, prepared by the state may have been pervasive to the jury. Listen, I'm just going to be honest, right? Maybe instead of bringing in the ex-judge, you could have hired like a 20-year-old who knows how to use PowerPoint, and you would have had a better presentation for the trial had the other guy handle the case entirely. It's not their fault that the state brought examples and evidence and presentations and showed step by step how things worked, while your side had Jackie step up and insult the jury. That's what happened, right? We've all seen the case. Most of us have. That's watching this, I'm assuming. Mrs. Adelson asked the court to look objectively at the evidence, removing the improper stacking of inferences on which the jury's verdict is premised. And now we have solicitation to commit first-degree murder. Now, what are they arguing here? The evidence admitted at trial failed to establish that Mrs. Adelson asked anyone earnestly or tried to induce anyone to murder Mr. Markel. Rather, the competent substantial evidence establishes that when Charlie was speaking with Mrs. Mambagwa concerning Mr. Markel, he would at times make or receive calls from Mrs. Adelson. Mrs. Mambagwa did not testify to any messages Charlie conveyed to her, and Charlie, although transported from prison to testify, was not called as a witness. You could have called him, defense. If it was a lie, you could have called Charlie. If you knew the state was going to make the argument there, and that's not what happened, the one who chose to not have the other side call, right? Like, they knew the state was going to bring that up. Their argument was, if I'm remembering right at trial, they tried to insinuate that maybe he was talking to another woman. Right. As with the argument concerning count 1 above, the evidence may have established her involvement after the fact, and her complaint to Charlie about how Mr. Markel treated Wendy Adelson, there was simply no evidence she commanded, encouraged, hired, or requested Mr. Markel be murdered prior to the murder. Common sense in plain language. Let's continue on. Court erred in a decision of any matter of law which arose during trial. Okay. The court erred in denying Mrs. Adelson's request to admit into evidence the complete 2014 and 2013 planner. The defense could not tell the judge what was important in the planner. The state said, here are the important parts, and the defense is like, what if we bury it? Right? The defense had a chance to explain. They couldn't. During trial, the defense sought to admit the complete planners to correct the misrepresentation expected to be made by the state, which came to fruition during the state's closing argument. The state argued that Mrs. Markel's tag number in the 2014 planner was evidence that Mrs. Adelson provided the tag number to the shooters, but there being no evidence this happened. Riviera testified there were words on the photo given to Garcia, but no evidence was offered as what those words were. With the 2023 planner, the state argued the planner indicated in anticipation of fleeing the country that Mrs. Adelson was selling personal items. Now, yeah, I remember this argument, but at the same time, I'm assuming everyone was like me. Okay, she's watching her son's trial fall apart. She knows how this is going to end, right? Like, I don't think anyone was probably unaware Charlie was going to be found guilty, right? So the fact that she's preemptively trying to sell things, or even out of fear, she might have started selling things way ahead of time out of fear she's next if Charlie's found guilty. And the argument they were trying to make is because she tried to sell things prior, she couldn't have been trying to sell things because she was leaving the country. Although that doesn't disprove that. If anything, it didn't work for me. I'm putting it that way. Admission of the complete planner would have corrected the misrepresentation made by the state, as there were 39 other entries in the planner where Mrs. Adelson listed to sell identical items as far back as January 2023. Okay. They're saying from 2023. That's still... When was Charlie arrested? I should know that. Anyway. Yeah, I don't think that helps her in any way. And they couldn't explain why it would help her to the judge either. In Curtis v. State, the court recognized that judges have a duty to admit evidence that does not fit neatly within the confines. As the court admitted portions of both planners, there is no question concerning the authenticity of the materials. Exclusion of the planners infringed on Mrs. Adelson's right to present a defense, and then the evidence was important to defeat the argument. She was fleeing to avoid prosecution. Thus, the court erred in excluding the planners as evidence. I don't think that's good. I don't think it's good and good argument. I think it's the best the defense has had in this so far, but I don't think that's going to fly. For other cause not due to Mrs. Adelson's fault, she did not receive a fair and impartial trial. Oh boy, I can't wait to see what's not her fault again. Specifically, the courts must vigilantly guard against atmosphere in and around the courtroom becoming so hostile as to interfere with the trial process, even though all forms of trial conform to the requirements of law. She sat there and made faces. What are they saying was so bad? The judge had to stop Donna for doing things like taking her headphones off and making sounds. This is a case where the cumulative effects of a number of factors constitute inherent prejudice Resulting in Mrs. Adelson not receiving a fair trial. When the court would rule against the defendant on many occasions, members of the gallery supporting the state would laugh out loud. I mean, were they laughing because it was denied, or were they laughing because your arguments were bad? Either way, was it? They talked previously about the jurors, right? The jurors being interviewed. Are they going to state that the jurors were in some way tilted by this, right? Because the judge admonished the jury a couple times for different things. So they are trying to argue earlier juror misconduct, right? Are they going to even bring up the jurors even hear this? The jurors pay attention to this. Counsel for the defendant brought this to the attention of the court, and the court appropriately advised the gallery that it was not acceptable. The court did this on more than one occasion. However, the conduct continued throughout the trial, and the court took no action to remove those who violated the order. This undermined the credibility of the defense in the eyes of the jurors. Not only were they laughing out loud, videos and images captured through the live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. I watched the live feeds. I don't remember this. If it didn't, I didn't capture my eye. The only time I can think of laughter, and I can't think of the exact situation, but I think it was due to something not loading or something, and there was some joking comment. But other than that, I don't remember catching it on the feed, and I definitely don't remember people making faces and trying to get attention of the jurors. I know a couple times the camera zoomed in on family members, but I don't know what they're talking about. And also, like, I don't know. It doesn't make sense to me. This interfered with the jurors' ability to focus on the evidence and distracted them from closing arguments. Again, you want to reference what the jurors said. Did any jurors say that? The court admonished the defendant on, so wait, Donna can do wrong. On numerous occasions that she was not permitted to show any emotion in the presence of the jury. The law does not require that a defendant appear without any emotion. In fact, in this case, appearing to be cold to the serious and evidence of the case may cause the jury to believe the defendant had no care or concern for what the victim endured. This person has too much emotion. This person doesn't have enough emotion. The court didn't allow Donna enough emotion. I don't know how. During the course of the trial, prior to the reading of the verdict, the defendant did not do anything to disrupt the proceedings. She repeatedly took her headset off that she claimed she needed to hear, suddenly didn't need it to hear the judge once the jury was out. She did become tearful during her first sight of autopsy photographs and got choked up when her children appeared to testify against her. She did not speak out. She was not sobbing out loud. She was not crying out. She did need tissues to wipe away her tears, but she made no noises that distracted the jury in any way. I mean, you're listing out things that are worse than what you claim the jury. The jury's attention is going to be on the defendant and the evidence, and you've already listed the defendant making more actions than anything they claimed the audience, which they're not going to be paying attention to, made. Even the victim's parents know that she showed no remorse. No fucking way. Due to her lack of emotion during the trial, this impacted the decision of the jury, resulting in Mrs. Adelson not receiving a fair trial. They are trying to use Dan Markel's parents to get Donna a new trial. My guess is that the ex-judge wrote that part. The state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense's case, the court demanded that Mrs. Adelson decide whether she would testify. Okay. Both counsel for Mrs. Adelson as well as Mrs. Adelson herself repeatedly advised the court that more time was needed to discuss the evidence, admitted pros and cons of testimony based on the volume and substance of the evidence, admitted during trial in order to make a knowing and intelligent decision. She's had since Dan was killed to decide whether she would testify in her eventual trial. Let's just put it bluntly. It was time. It was time for her to decide. She's had more time than most witnesses, and she's deciding to the last minute, right? The most important decision in her life is especially significant in that the state made numerous changes to evidence during the trial. So they're trying to play around it. Well, see, it's the state's fault Donna couldn't decide. When the court recessed early on September 2nd, 2025 to allow counsel to meet with Mrs. Adelson, we first spent a great deal of time reviewing the exhibits actually admitted so that we could discuss them with Mrs. Adelson. Should have not been her first time seeing them since they were admitted. Counsel then drove to the detention center to meet with Miss Adelson for the 2 hours authorized, arriving at approximately 5 p.m. Counsel did not have enough time to go through every exhibit with Mrs. Adelson during its meeting. Counsel advised the court of this matter the following day when the court inquired about Mrs. Adelson's decision. Not only did the court force the defendant to make an uninformed decision, she's had plenty of time, he threatened to hold counsel for the defendant in contempt of court because they were continuing to speak to the client about this important decision that she had to make. Yeah, he told you to stop talking. An ex-judge would not stop because she just didn't care. There are moments in this trial where the judge is speaking and she has her back to him, packing things up, not paying attention. Which again brought an audible derogatory response from the gallery. Okay, guess what? If true, guess what? The jury wasn't there. They're going to argue, well, it makes the whatever type of hostile courtroom. You were just doing something that the judge threatened you with contempt for. Now, who is in more wrong in that scenario? The defense attorney being contemptuous or someone laughing at that in the audience? Which one is worse? Oddly enough, whenever the state needed additional time to set up electronics for opening statements, they're arguing here about when there was technology issues, when it didn't work. Not their stuff, the courtroom stuff didn't work. But again, you could have used technology if you had picked different defense attorneys. Let's continue. For witness testimony, closing arguments, or even additional time to make their closing argument. Didn't their closing argument get cut off at one point? And didn't the defense interject like twice during their closing argument too? The court not only gave them the additional time, he joked with the prosecutors about it, thus leaving the clear impression they favored the state in this case. Surely the decision of a defendant facing life in prison is more important than the extra time the state requested to conclude his closing argument. The defendant's request was not granted and made a huge impact on the outcome of the case. So she regrets not testifying. That's her fault. The court showed favoritism to the state at most every junction of the trial. While the trial had delays starting times to accommodate the state's need, the defense was required to meet its tasks over lunch breaks, thus not allowing counsel adequate to meet the obligations of the counsel for the trial, resulting in the inability to consume lunch over the break. I want you to take a moment and put yourself in defense counsel's shoes. This is a life case, right? The end of this, like, this is a case. They're going to be put away for life if they're found guilty. So, your argument is you weren't prepared. You, the defense, weren't prepared. So it's the judge's fault that what, you drank a Monster during lunch instead of a full lunch? Are you going to now argue your macronutrients weren't met by the lunch you packed yourself? There was so much time they had in this case to put everything together, and they botched it. The defense botched this. If Donna Adelson is to get a new trial, it will be something involving ineffective assistance of counsel. In my opinion, that is the only shot she has. And that'll come in the appeal. This is a motion for a new trial. The court sustained the ejection of the state without giving the defense an opportunity to respond. I remember a couple of those instances, and it was things that the judge had already ruled on. And again, it was the ex-judge making the arguments. I always thought everything she did was terrible in this case, if you can't tell. But also, it was that, and I think I can't think of it right now, the exact thing, but there was one that seemed ridiculous, and it was just a denial. Under some situations, sidebar arguments were made, but on more than one occasion, the court denied the defense's request to approach. Additionally, even when the court sustained the defense's objection at a sidebar, when the sidebar concluded, the court announced to the jury that the ejection was overruled. I can't say one way or another the sidebars aren't public yet. And if you're wondering, they should be. Eventually. Probably with the appeal. Sarah Boone, her stuff was made public, the sidebar stuff, because of the appeal. During one sidebar discussion, the court asked counsel a question. As counsel attempted to answer the question, counsel was met with a scolding to not talk over the court. Counsel thereafter was prevented from answering the court's questions. I am fully expecting this to end up being, if this comes out, it'll be ex-judge interrupting the judge, trying to talk over them to answer a question that wasn't even fully asked yet. I'm going to make that guess. Like, if I had to guess who on the defense side is doing that, the temperament of the court towards the defense counsel was regarded as negative and gave the appearance of partiality for the state on part of the court. Not only the defense, but the spectators in the gallery, the media, those viewing the trial through the media. My negative opinion of the defense has nothing to do with the judge. I want to assure you of that. Fellow defense attorneys commented they had appeared before the court in trial on similar charges, and they were shocked to see the obvious disdain the court showed toward Mrs. Adelson and her counsel in this case. Name them. Name them. Although there is a standard jury instruction to the jury that they are to disregard anything the court may have done that led him to believe he favored one outcome or the other, and that was read in this case, it is not realistic that a jury can set those feelings aside. The jury clearly disregarded the instruction of the court on other issues and did so on the instruction as well. So we're arguing here that the jury was swayed by emotion, swayed by no emotions, and swayed because the defense was bad at their job. The totality of circumstances present during Mrs. Adelson's trial established inherent prejudice. To it, there's an unacceptable risk of impermissible factors coming into play. Literally, this sets up, though, I really think this whole thing sets up incompetent defense arguments at the appeal. It's like, look at these numbskulls. Look at all these issues they caused her. This might be more of the defense giving her ammo for that appeal than anything else. Seeing how it plays out. Therefore, the totality of circumstances present during Ms. Adelson's trial establish prejudice to wit. There's and then she wants to have a new trial, and then it's signed, and yes, the ex-judge does use the address of a crematory for her signature. So that's where we're at. In the Donna Adelson case, I think that this is obvious nonsense. I think that I normally, like, when I read these, it's obviously grasping at stuff. They're like arguing against themselves at multiple points. That's how bad I think this is. I think they are fighting themselves, and it's just a, I don't think it's gonna work. Like, the chances of it working ever, low. The chance of this working, pretty much zero. Let me know what you think in the comments. I don't know. I'm a little blown away that they tried to use Dan Markel's parents to get Donna a new trial. That's what stuck around. That's what stuck with me. That's the part I remember.